I'm Lauren Hewitt, General Manager of Policy at AgForce Queensland.
And I'm Mark Boge, Solicitor at Thynne Macartney, who does AgForce's native title legal work.
We've just got back from a really interesting Senate inquiry hearing, so I'll let Mark explain a little bit about the hearing. We do native title law for AgForce, and it's a pretty big portion of what we do for our members and Queensland pastoralists generally. Mark, can you explain why?
The legislation that the committee's looking at amends provisions of the Native Title Act in light of a decision of the full court of the federal court that calls into question the validity of a number of ILUAs. The issue before the full court was that a number of agreements had been signed by some of the appropriate people, but others who needed to sign were refusing to sign. So the court said you can't register those agreements.
So what really seems to be an issue between our members is this question of what sort of ILUA is it? We've got different types of ILUAs. Extinguishment ILUAs, where essentially you're asking the native title applicants to give up and forgo all of their future rights, and land use and access ILUAs. Now, Mark, which are you talking about?
For our members, we're talking about the use and access agreements. So these are agreements we've done to complement a native title determination. So our members know, for example, who they have to speak to about native title, and the native title holders know who to speak to about accessing property and getting permission and that sort of thing.
So the McGlade decision, which is the Western Australian decision which has caused this bill to be drafted, essentially is an extinguishment ILUA, and it's a situation where a portion of that claim group refused to sign the ILUA, and now that ILUA is being questioned in terms of its registration. In Queensland, we believe that we're largely unaffected by those sorts of provisions, mainly because our ILUAs are uncontroversial because they're to get access to the property. They're land use and access ILUAs, and therefore it's probably of little interest to the Senate. But we did a fair 45 minutes questioning in the Senate hearing today, Mark.
We did, and I think one of the things they were interested to know was that we've signed up to these ILUAs on the basis that they're forever. So while ever we've got the lease, we're going to have the agreement. In
conclusion, I guess we've got a few messages. Firstly, to the Federal Parliament and Senate, we need these laws passed.
So we don't want the ground moved from under us. So we just want this thing to go through and leave everything the way it is. We've got agreements that have been on foot now for 6 odd years. We just don't want any doubt thrown on them.
For our members, the message is native title is a real and ongoing issue. If you're on a term lease, native title is likely to still survive, and that's why we need the ILUAs, so that we have terms and conditions upon access and how that's to operate. We're looking after your legal interests and making sure that we have a process which stands up and actually works practically on ground, and that's why we were appearing before the committee today.
That's right, and that's the message we gave them too.